Welcome to this interactive study guide explainer. Today, we are cracking open one of the absolute most famous domestic disputes in legal history. I'm talking about the landmark 1919 case of Balfour v. Balfour. If you've ever wondered why the law treats, say, a formal business deal totally differently from a promise made between a husband and wife, well, this is the explainer for you. We're going to use this fascinating case to unlock a massive concept in contract law, specifically zooming in on Section 2H of the Indian Contract Act. So grab your notebooks because this is going to be really interesting.
Here's our syllabus for today. We'll be hitting the facts of the case, the main arguments and final judgment, some core contract definitions, a real deep dive into Section 2H, established legal principles, and then we'll wrap up with some practice questions to test your knowledge.
All right, let's jump right into part one, the facts of the case.
To really get why the court ruled the way they did, we've got to map out the timeline. Picture this. It's 1915. Mr. Balfour is a civil servant working over in Ceylon, that's modern-day Sri Lanka, and he and his wife take a trip to England on leave. But just a short time later, Mrs. Balfour falls ill. Her doctors basically tell her that she needs to stay in England to recover instead of traveling all the way back. So right before he heads back, Mr. Balfour makes a promise. He says he'll pay his wife £30 a month until she's well enough to join him. Now, initially, he actually makes the payments. But as time goes on, the relationship sours, they end up separating, and those monthly payments, they completely stop. And it was that single stopped payment that triggered a massive, full-blown courtroom battle. Which brings us perfectly to part two, arguments and final judgment. When they got to court, there were two totally different ways this £30 promise was being framed. Mrs. Balfour's argument was super straightforward. She said, hey, my husband made an express, voluntary promise of £30 a month, and I relied on that promise by staying here in England. Therefore, to her, it was a binding contract. But on the flip side, look at Mr. Balfour's defense. He argued that this was not some formal business transaction. This was just a promise made within an ordinary marriage. It was a domestic arrangement. And the absolute key here, he argued there was never, ever any intention for it to carry actual legal weight. So the Court of Appeal had a pretty tough call to make, and ultimately their final judgment came down in favor of Mr. Balfour. They completely dismissed Mrs. Balfour's claim. Why? Well, the court basically ruled that ordinary family arrangements, like a husband promising an allowance to his wife, are legally presumed to not intend legal relations. Essentially, the court was saying it really has no business policing the everyday promises spouses make to each other.
Moving on to part three, core contract law definitions.
We're going to start with Section 2A of the Indian Contract Act, which defines a proposal or an offer. The Act states it is signifying a willingness to do or abstain from doing something with the intention of obtaining another person's assent. Sounds a bit wordy, right? But let's apply that directly to our case. Mr. Balfour's promise to pay £30 a month definitely looks like an offer. He signified his willingness to pay her in order to get her agreement to stay in England. But we've got to put on our lawyer hats here and ask the tough question. While it was definitely an offer, did it actually have the necessary legal backbone to form a contract? Keep that in the back of your mind. Next up, we have Section 2B, which defines acceptance. This one is pretty simple. When the person receiving the proposal signifies their assent, when they basically say yes, the proposal is officially accepted. So how does this fit in? Well, Mrs. Balfour clearly accepted the arrangement by staying in England, exactly as they discussed. So we've got an offer and we've got acceptance. Boom, right? Well, not quite. As any law student knows, acceptance alone does not automatically wave a magic wand and create a legally enforceable contract. It's a crucial stepping stone, sure, but the equation is still totally incomplete if you don't have legal intent.
And that brings us to Section 2E. This section defines an agreement as every promise and every set of promises forming consideration for each other. When Mr. and Mrs. Balfour exchanged their promises, they absolutely formed an agreement. There's literally no denying that. But, as we're about to see, not all agreements actually cross the finish line to become valid contracts.
Let's get into the real meat of this in part 4. Deep dive into Section 2H.
Section 2H of the Indian Contract Act states simply, yet incredibly powerfully, an agreement enforceable by law is a contract. I really want you to let those words sink in. It brilliantly illustrates the massive, gaping legal void between a mere agreement and a valid contract. The magic bridge connecting those two concepts? It's that word right there, enforceability.
So let's break down step by step exactly why the Balfour's 30-pound agreement failed this strict enforceability test. First off, because they were spouses living together, their deal was legally presumed to just be a standard domestic arrangement. Second, because it was a domestic arrangement, it severely lacked the intention to be legally bound. Nobody was calling their lawyers to draft this up, right? So without that intention, the third point is that it was not enforceable by law. And therefore, finally, it never crossed that magic bridge to become a true contract under Section 2H. Was it an agreement? Yes. Was it a contract? Absolutely not.
All right, Part 5, Established Legal Principles.
Here is the core ratio decidendi, the fundamental, underlying reason for the court's decision that you absolutely need to memorize for your exams. Number 1, domestic and social agreements are generally not contracts. Number 2, an intention to create legal relations is completely essential. Listen, even if you have an offer, acceptance, and consideration, without intent, you've got nothing. Number 3, it's super important to note that the presumption against enforceability can be rebutted, but you need incredibly clear evidence to the contrary. And number 4, quite simply, not every single promise made inside a family amounts to a legally binding contract.
Let's put all of this to the test in Part 6, Practice Questions.
Okay, here's your first scenario. Let's say a husband promises to buy groceries every single month for the household, but then he fails to do so. Is this promise legally enforceable in court? Think about the precedent we literally just established. What would a judge say?
The answer? No. Based directly on the Balfour principle, this is just a standard social arrangement. It completely lacks the intention to create legal relations, and because of that, it completely fails the strict test of Section 2H. The courts are definitely not going to force someone to buy groceries for their spouse under contract law. It's just not going to happen.
All right, next question to test your critical thinking. Can the legal presumption against enforceability in family arrangements ever be challenged or overturned? Or is it just an absolute, unbreakable, ironclad rule?
The answer here is actually yes. In law, you'll find there are almost always exceptions. The presumption that family arrangements aren't legal contracts can totally be rebutted if the specific circumstances clearly show that both parties actually intended to be legally bound. Say, for example, if they signed a formal written legal document with their lawyers present. Well, that contrary intention can absolutely displace the standard domestic presumption.
As we wrap up this explainer, I want to leave you with this final kind of provocative thought. If every valid contract under Section 2H requires an agreement, does every agreement require a contract? Think about the everyday promises you make to your friends, your family, or your partner. How many of those are just agreements, and how many are true, legally binding contracts? Understanding that specific boundary is literally the beating heart of contract law. So keep exploring, keep questioning, and definitely use this study guide to ace those upcoming exams.